Yes, Mr. Strong.
Thank you, my lady. Just in answer to a question that was asked this morning about agreement with Lord Steyne in Mullen, the head note suggests that Lord Roger and Lord Scott agreed with Lord Steyne. That's electronic reference 729. I think, in fairness, I cannot necessarily see the agreement by Lord Scott when you read the judgment.
It's not there.
No, so I think it seems to me it's Lord Roger who agreed with Lord Steyne.
On that point.
On that point.
Yes.
And
Well, the more confusion there is, the easier it is for us.
of course. And can I just finish on the topic of applicability? I covered with the court the question of the approach in Allen. There are, of course, the subsequent chamber decisions of ALF, KF, and Adams in the UK, which you have in the authorities. Those are all, in my submission, chamber decisions which follow on immediately from Allen and simply apply the reasoning in Allen, but without any further elaboration or consideration. And in my submission, don't take the matter further.
What qualifies as a clear and constant line of jurisprudence?
A clear and constant line, in my submission, my Lord, would be certainly two decisions from the Grand Chamber. And I can see that a body of case law that applies a decision of the Grand Chamber in subsequent chamber decisions where there's been the opportunity for further debate might also. But in fact, in KF, ALF and Adams in the UK, as I read them, there wasn't the opportunity for further debate with the government. Two of them at least are admissibility decisions without being notified to the government. And I think one, the arguments would have been in place before Allen. The consequences of Allen were appreciated.
There must have been the opportunity, surely, for debate. But if the opportunity wasn't taken...
Well, the opportunity doesn't arise if the cases aren't communicated to the government. And I think ALF, and certainly Adams, were simply dealt with...
the other one? Adams and
ALF were simply the court deciding admissibility without reference to the government, but applying the decisions. And of course, in all of those cases, the Strasbourg court was actually finding no violation of Article 6.2. So hence, although they were applying Allen in terms of applicability, they went on to find no violation. So there wasn't actually the need to communicate them to the government in the circumstances. So in answer to my Lord's question, I submit it involves jurisprudence which involves some dialogue or debate which enables one to be satisfied of the constancy of the jurisprudence. That said, I recognise the principles this court has expressed about Section 2 of the Human Rights Act, and in our printed case, and I wasn't going to take the court to all of them, the Horncastle, Pinnock, Chester cases which set out the reference to clear and constant line of jurisprudence and the circumstances in which one might not follow a decision. And we dealt with that in our printed case, paragraphs 42 to 48. We've cited the relevant authorities, I hope. And what we have identified in paragraph, give you the electronic page reference. It begins at page 158. And at paragraph 44, we have referred to this court's later decision in Khayyam and the judgment of Lord Manson, Lord Hughes, joint judgment of Lord Manson and Lord Hughes, dealing with the principles that are expressed in the Chester and earlier in Pinnock. And in our submission, qualifying the adjectives that might be applicable, egregious oversight and matters of that kind, as not setting necessarily strict tests. And in our submission, perhaps the way to test, or the touchstone of this, is whether the matter is susceptible to further dialogue, meaningful dialogue with Strasbourg. And that is really tested by looking at the way they've analysed their decision. And so that if the court considers, as I've submitted, that there are things that need further elucidation or consideration, such as the restrictive criteria, the lex specialis points, and the position or the conflict with the Human Rights Committee and the other international covenant, these are matters which are capable, and indeed, I submit, should be looked at in greater depth by Strasbourg on that question of applicability. And so in those circumstances, we do say this is one of those rare cases where we invite you to allow that dialogue to continue by continuing to apply the domestic law position and giving Strasbourg the opportunity, should it so wish, to consider that question of applicability again. I turn to the second topic, or the second main point, submission. If Article 6.2 is considered applicable by virtue of Allen, is it necessarily infringed by Section 133 or infringed in these cases? And can I try and structure my response into three parts? First, just to deal with a summary anatomy of the Strasbourg jurisprudence on Article 6.2 and violations in this context. Secondly, to turn to Allen itself, bearing in mind the submission made by the appellants that they say it's definitive on this point, namely compatibility of 1ZA, a surprising submission, I submit, bearing in mind the statutory provision wasn't in front of the Strasbourg court. And thirdly, an analysis of 1ZA itself in light of those two things. As to the anatomy of the Strasbourg case law, the Strasbourg court itself, in the Allen decision, did of course set out a number of the principles that have been applied in other contexts. And you'll find that in paragraphs 120 to 124 of their judgment, tab 11 of volume 1. And this is under the heading, the court's approach in previous comparable cases. And you'll see that in paragraphs, sorry, it's 969, I'm so sorry, of the electronic one. And you'll see there that there is some analysis of cases beginning with Minelli through to Secanina and subsequent cases, and I'll just come back to that in a moment. The end point is paragraph 125. It emerges from the above examination of the court's case law under Article 6 that there is no single approach to ascertaining the circumstances in which that article will be violated in the context of proceedings which follow the conclusion of criminal proceedings. As illustrated by the court's case law, much will depend on the nature and context of the proceedings in which the impugned decision was adopted. And then in 126, in all cases and no matter what the approach applied, the language used by the decision maker will be of critical importance. We've already looked at that in the context of what was said about Orr and Norway, for example. But taking that as read, because we've already looked at it, it carries on in cases where the court's judgment expressly referred to failure to dispel the suspicion of violation of Article 6.2 was established, see Secanina. However, when regard is had to the nature and context of particular proceedings, even the use of some unfortunate language may not be decisive, and there's some examples of that. Can I just, that's the court's own conclusion as to where it gets to looking at all its case law, no single approach. But can I just put a little bit more context on that? What there is, even identified in paragraph 121 and 122 of that same judgment, is certainly a definable principle referring to Minelli and Secanina. there is what's described as the Minelli principle in paragraph 121. It's described as the Minelli principle later on in 122, and then the Secanina principle. And it's worth understanding what those principles are. The Minelli principle begins with the Minelli and Switzerland case, referred to at paragraph 120. And I'd like to pick up the thread, if I may, at paragraph 121. In the first cases with which it was confronted, the court that is, concerning applications by a former accused for compensation or for defence costs, the court drew on the principles set out in Minelli, explaining the principle. And if one just reads on what's there described. And at the end of 121, in finding no violation of Article 6.2, the court explained the domestic courts are described as state of suspicion. Their decisions do not contain any finding of guilt. And that is contrasted with the Secanina principle. In the subsequent case of Secanina, there's a distinction between cases where criminal proceedings are discontinued and where there's a final acquittal judgment. In the latter, it's no longer admissible to rely on such suspicions once an acquittal's become final. The reason this is significant in this context is when the court came on to consider what is going on in section 133 terms, paragraph 127, they decided that the position is that the acquittal in this context, page 971, in the court's view, is not an acquittal on the merits in a true sense, compare and contrast Secanina. In this sense, although formally acquittal, the termination of the criminal proceedings against the applicant might be considered to share more of the features present in cases where criminal proceedings have been discontinued, that being the Minelli principle, and that being the principle that the voicing of suspicions against the accused is permissible without infringing Article 6.2. And if one considers that in the context of the Allen case itself, which the Strasbourg court found compatible, you'll recall from the discussion yesterday in Allen, the domestic courts had identified a strong case still to answer on the documents that remained in Allen, and that's consistent with the court's finding that there was no violation in identifying a strong case still to answer. It's consistent with the Minelli principle that if this is not a final acquittal on the merits, expressions of those sorts of states of suspicion, as the Strasbourg court would describe it, are perfectly permissible. But the three cases the court refers to in paragraph 121 are, and they're all in the bundle, Lutzen, Germany, Nocklenbocken, Germany, and Englert in Germany. The references in the bundles, I'm not going to turn them all up, are 1787 for Lutz, 1810 for Nocklenbock, and 1829 for Englert. 1829.
What was Lutz? 1787, yes.
Yes.
1787.
Lutz is 1787. And in fact, I could make the same point by any of them, but I'm going to do it by reference to the Lutz case. So if the court would turn to that, that's in bundle 4, tab 32. These decisions actually all came out on the same day. But Lutz in Germany, Mr. Lutz was charged with a road traffic offence, which was, in the court's judgment, correctly treated as a criminal charge. There was a debate about that, but it was concluded that it was a criminal charge. And if you see from the facts on page 1788, the nature of the offence is described at paragraph 12. The severity of the offence doesn't matter. It was a minor offence in this case. They range depending on which case you look at. But the important point was that Mr. Lutz sought costs as a result of a subsequent acquittal arising from the case becoming time barred, and you can see that from 1789, 3/4 of the way down, on 24th of July 1981, the court informed the applicant that it intended to discontinue the proceedings as they were time barred. It ordered costs against the Treasury, while the applicant would have to bear his own necessary costs and expenses. In the reasoning for making that decision, there was a discretionary scheme for awarding costs, and the court, in deciding not to award Mr. Lutz's costs, over the page at 1790, set out its reasons. And if you read just above paragraph 17, you'll see, as the file stands, about halfway down, the defendant would most probably have been convicted of an offence. So it's a review of the evidence and a conclusion that the person would most probably have been convicted. That, in fact, became strengthened, if you look at the page, top of 1791, where there was an appeal against that decision, top of 1791, defendant would almost certainly have been found guilty of an offence. So the appeal court reaching perhaps an even more certain conclusion. And the circumstances then arose of a complaint of Article 6.2 in that context. And the Commission have found that these sorts of findings were a breach. By contrast, the Strasbourg court itself concluded they were not. And you can get that from the decision which comes beginning at 1804. And in particular, paragraph 60 through to 62. To 1805. And I now ask you to note, particularly at the end of 1805, on the basis of the evidence, in particular the early statements, the decisions described a state of suspicion, did not contain any finding of guilt. So almost certain, saying someone's almost certainly likely to be found guilty fell on the right side of the line. Now, one can find similar decisions. Knocklenboff, a similar case, paragraph 18 of that judgment, the Court of Appeal refusing compensation found the defendant's conviction would almost certainly have been upheld. And Englert in Germany, the circumstances rebutting the presumption of innocence are, in the view of the chamber, that's the domestic chamber, so overwhelming that a conviction is clearly more likely than an acquittal. And in all of those cases, the Strasbourg court concluded that because no final acquittal on the merits, these were describing states of suspicion on the right side of the line. Then came the Sekanina. So I'm not going to take the court to all of those, but you'll see, I've given you the references to where those judgments start. Then came the Sekanina case in chronological order, 1993, and you've already been taken to that. It's tab 35, page 1846, and that qualified the Minelli principle in the way the court described, because there had been a final acquittal on the merits. In that case, Mr. Sekanina had been acquitted by a jury following a criminal trial. And the Minelli principle was qualified to the extent that where one had been so acquitted, and this is paragraph 30 of the court's judgment at 1860, I should just give you the reference to the page before, 1859, paragraph 28. That's where they distinguish the Englert and Knocklenboff cases. But where you have an acquittal by a jury, for example, paragraph 30, the voicing of suspicions regarding an accused's innocence is conceivable as long as the conclusion does not result in a decision on the merits of the accusation. However, it's no longer admissible to rely on such suspicions once an acquittal has become final. consequently, the Regional Court, Linz Court of Appeal reasoning was incompatible. And that reasoning had been about a scheme which required one to have dispelled suspicion in order to qualify for compensation. So if one were worried that Sekanina represents a departure or change in the law, you can see that that's not the case, because in the subsequent decision of Leutscher and the Netherlands, which came in 1996, and at least 3 of the judges were the same as Sekanina, page 1863, the court adopted the Minelli principle again in concluding that on a time-bar discontinuance case, it had been permissible to continue to voice suspicions. And you can get that from the court's judgment, page 1875, paragraph 26, the applicant's argument, and then at the bottom of 1875, the court, like the Commission, recalling its established case law. And over the page.
Why is this dichotomy then, Mr. Strawn? We are all presumed innocent. We don't need an acquittal. We are innocent now. So this business of, discontinuance is one thing, acquittal is quite another. Why does that inform the application of the presumption?
As I understand the concern of Strasbourg, and it's based on this distinction, the aim is that subsequent statements by courts or public authorities should not undermine the effect of a formal acquittal. Where one has not been acquitted on the merits, as they describe it, and the process is more technical, i.e. it's been stopped by time bar or insufficient evidence, or as in the case of our jurisdiction, quashed on a criminal appeal, it's legitimate to refer to the state of the evidence that continues to exist against an applicant in deciding on questions such as compensation. And it's legitimate to distinguish between applicants on that basis, hence Lutz and Knocklenboff. Where someone is formally acquitted by a jury, the concern is a subsequent decision should not start from any presumption that they have to then prove their innocence. And so a voicing of suspicion might have that effect if one referred to the judgment. That's as far as I understand the substance of the case law.
Thank you.
And what's being got at. But the critical point, of course, is if you're entitled under Lutz and Knocklenboff and Leutscher, as the Strasbourg Court has affirmed, to voice suspicions, as they would describe it, where there's not been a formal acquittal on the merits, be that saying, well, there's still a strong case to answer, for example, or you almost certainly would have been convicted on the state of the evidence as it remains, see Lutz and Knocklenboff. It cannot, in my submission, sensibly be said that a contrary description of the state of the evidence, i.e. there is no suspicion against you, somehow infringes Article 6 in those circumstances. So if in the context of no acquittal on the merits, the conclusion is, having looked at the file, you did not commit the offence, as opposed to, well, there's still a strong case to answer, it's inconceivable in my submission to say, one, i.e. the identification of suspicion doesn't infringe Article 6.2, but identifying that there's no suspicion on the state of the file would infringe Article 6.2. That seems, in my submission, to be a rational result.
So surely the infringement is not that statement. The infringement is requiring someone to prove that statement.
Well, if it's a question of proof, requiring someone to prove a state of affairs, of course, that takes one into a different territory. Section 1331ZA is not about requiring someone to prove something. It is about the Secretary of State examining the new or newly discovered fact to see what it demonstrates.
Well,
and that is...
put it in terms of requiring someone to prove, making it a condition of compensation that.
Well,
isn't that just as bad?
In my submission, not, for two essential reasons. The first reason is, as I've said, is not putting someone to proof. It's merely describing what a particular fact does or does not do in the process. It's not actually going to determine general guilt or innocence. As I already indicated, you could actually be innocent but not get home on even 1ZA. For other reasons you may have demonstrated innocence. So it's not objectionable. And the second link to that is, of course, the whole question of what, in this case, 1ZA is directed at, namely identification of a miscarriage of justice. And miscarriage of justice is circumstances where the new or newly discovered fact that's come in late in the process is the thing which demonstrates someone didn't commit the offence. It's the thing that has come in. That's classified now as a miscarriage of justice. But that's not going to the central question, which we later find objectionable in these schemes, of asking the decision maker, notwithstanding the acquittal, to make some more generic finding as to whether someone's guilty or innocent. That's where the device, as far as Strasbourg, comes in. And I'm just going to, if I can just show you in terms of that. Leutscher, therefore...
What you have shown with these cases, Lutz and Leutscher, is why Lord Pannick's amendment, or why Category 2 in Lord Phillips's categorisation is acceptable.
Well, I didn't think it was in doubt that Category 2 was acceptable.
No, but I mean, one wondered why it was acceptable when it involved, on the face of it, a voicing indirectly of a suspicion. Yes. But the answer is that in a context where there hasn't been a final acquittal, that's not a problem. You can say, look, there's matter to go to the jury. There's plenty to suspect.
Yes, but I do put, the logical, if I could just take that one stage further, the logical consequence of the Lutz and Knockenbach-Englert case is that under the discretionary scheme, if a court reviewing the file looked at the state of the evidence and said, well, having looked at your acquittal and seen that, for example, there's DNA evidence that shows you weren't the person who committed the offence, to say that and award compensation on that basis, in my submission, couldn't be objectionable either. Even though you are allowed to express a strong state of suspicion based on the existing evidence, but to say there's a piece of evidence which says, well, there's no suspicion against you, as a matter of principle, isn't a violation by definition of Article 6.2 if the contrary isn't. In my submission, that's the logic of the analysis.
Are you treating Allen as an example of the non-final determination or an example of the Seconina type of situation?
In my submission, it's the example of the former, according to what the court has said.
I see. All right, well, that's the answer anyway.
And that seems to be reasonably clear in paragraph 135, because however strangely, the court observes that the defendant didn't argue that there ought to have been a retrial. I'm not sure I've ever come across a defendant arguing that there should be a retrial, but they seem to have said, right, well, you lost the opportunity of having a final acquittal. You deprived yourself by not insisting on being retried.
I think in one of the cases, in the Alley case, there was someone who did ask for a retrial.
Well, it may have
circumstances,
but more experienced criminal judges than me.
But in any event, so Leutscher then follows Brischetti and Wechselbraun in Austria. I don't need to trouble you with, because they're exactly the same schemes that were an issue in Seconina and concern decisions after acquittals by juries, and that were considered to breach Article 6.2 for the same reasons as in Seconina. And then, of course, you have the Hallam case I've already taken you to, and the O and Norway case. The Netherlands schemes, Bars and Netherlands and Del Larte and Netherlands, can I just illustrate this by reference to Bars and Netherlands, Volume 4, tab 45, page 2014. This again was an application of the Minnelli principle on the basis that there had been an acquittal, but not on the merits. You can see it from the head note, H1 on page 2014. The applicant's prosecution was declared inadmissible because of violation of the reasonable time requirements. And in that case, someone arrested on forgery charges, the Court of Appeal, in refusing compensation, stated that the applicant would in all likelihood have been convicted. But that might seem to be close to the Lutz and Knocklenboff type case. But in fact, it was more than that. If one turns to page 2017, in rejecting the claim for costs and expenses and compensation, the Court of Appeal, you can see in the insert about a third of the way down, the Court of Appeal takes the view that this receipt, and it was about forgery, was forged by the applicant together with B, who was then an alderman of Maastricht. And on the application of the Minnelli principle, there was a violation found of Article 6.2, see page 2019, paragraph 21 through to 31. And in particular, paragraph 29, in the present case, however, the Court of Appeal based its decision not to make any award to the applicant who had been charged with the forgery on its view that the receipt had been forged by the applicant and enumerated in detail the elements from which this followed. So that went beyond strong states of suspicion to actually a positive conclusion that the criminal act had in fact been committed on the strength of the evidence. It's a continuation of the Minnelli principle, but on the facts, Strasbourg concluding you've gone too far, as you can see. And the same occurred in Del Larte in Netherlands. And these are simply applications of the principles on the facts as to the way the court then expressed itself. That brings me on to Capo in Belgium, fight on which the appellants place most store, along with Puig Panella. But the cases are very similar. Capo in Belgium is in bundle 5, tab 50. And it begins 2082 in the electronic bundle. Someone had been arrested on suspicion of arson, and the proceedings were subsequently discontinued. And you can see that from head note 1. The scheme in question, as the court looked at yesterday, is explained on page 2085. The compensation was dependent upon the applicant under section 28(1)(b) establishing his innocence by adducing factual evidence or submitting legal argument to that effect. So it's a discontinuance case, but the compensation scheme requires proof of innocence in a general sense. And in paragraph 25, the court's wording as to why there was incompatibility bears close attention. The court notes the appeals board refusal was based solely on the fact the applicant had not supported his compensation claim by adducing evidence of his innocence. So pausing there, notwithstanding the acquittal, the applicant is put in the position of having to demonstrate innocence by positively producing evidence to that effect. And that in itself reverses, so the court went on to conclude, any presumption of innocence. And it continues by, although being founded on the law of 1973, such a requirement, and then these words, without qualification or reservation, cast doubt on the applicant's innocence. And again, pausing there, it is impossible to describe Section 133 or Article 14.6 as being a scheme without qualification or reservation. Indeed, the whole structure of the scheme is dependent upon qualifications or reservations of the type I went through. There has to be a new or newly discovered fact, for example, and it's the new or newly discovered fact's effect and its effect on the evidence which is critical. Contrast here that one starts with a clean sheet, save that there is a presumption against the applicant where they are presumed effectively guilty unless they can establish their innocence without qualification or reservation. And it's that which allows doubt, as the court went on to say, to attach itself to the correctness of the decisions by the investigating courts. And again, pausing there, no such doubt arises under Section 1331ZA by virtue of concentrating on the new or newly discovered fact of whether it shows one did not commit the offence, because that is not the same nature of the exercise. One is presumed innocent, one is treated as innocent under 1331ZA of the offence. The Secretary of State's task is then to look at the new or newly discovered fact to understand what its effect was in the overall composition. And then the Minnelli principle is expressed. It's true, the voicing of suspicions is conceivable, etc. And they identify this as a discontinuation case. And then these words, however, the burden of proof cannot simply be reversed in compensation proceedings following a final decision, requiring a person to establish his or her innocence, which suggests that the court regards that person as guilty, is unreasonable and discloses an infringement of the presumption of innocence. And yes, of course, that suggests that a bare compensation scheme that starts with a presumption of guilt and you having to demonstrate innocence without more, without qualification or reservation, raises these very questions, because your acquittal is set at naught, and you start with the presumption, well, you demonstrate, bring some evidence to show you're innocent. That is in clear contradistinction to Section 133 and the nature of the exercise that's required. And of course, indeed, Article 14.6 itself, even without the definition of miscarriage of justice, which the 1ZA supplies. And so my submission, whilst the appellants place, as I said, great emphasis on Capo and Belgium as moving the position, it does no such thing. It actually merely endorses the general point about the importance of the presumption of innocence following an acquittal, meaning that one cannot simply reverse it in a bare compensation scheme of this nature. But it says nothing about the nature of a Section 133 scheme, and indeed the differences are all of those which I've already set out. I can therefore take the next cases quite shortly. Puig Panella is an example of the same principle, albeit it was a Spanish scheme, where the court required an applicant coming or seeking compensation to demonstrate the imputed facts didn't occur. No qualification or reservation, and the court starting again with an assumption effectively of guilt. And in that sense, it adds nothing to the picture other than to confirm the approach in Capo in Belgium, which I've already identified. And or in Norway is a civil compensation claim, which I've already dealt with. I don't need to spend any time on that. So that then brings me, having looked at the case law from the Strasbourg perspective, to Allen itself, to see whether that changes the picture. And in my submission, it doesn't. Because when you look at the decision in Allen, thank you very much. the decision in Hallam is in effect in paragraphs 120 to 125 merely reiterating the relevance of the Nelly principle and the Seconina principle, not in any way suggesting it's disapproved of, and that leads to the 125, paragraph 125 point, sorry, I'm 969 in the electronic bundle, 970. And then one comes to 127, which is the application of those principles to section 133. And 127, in my submission, says it's akin to a discontinuance case. 128 emphasizes the importance of the restricted criteria. Now, I've made a criticism about that appearing in this section rather than applicability, but it's, to some extent, swings and roundabouts, because as long as it's taken into account here, it means that one is effectively saying you won't breach Article 6 by virtue of having restrictive criteria. Indeed, they are the qualifications and reservations to the compensation scheme of the sort which didn't exist at all in Capo and Puig and Pinella, but the sort of qualifications, and the fact there are qualifications cannot necessarily be a breach of Article 6, otherwise it would make a nonsense of the two sitting together as they do in Article 3 of Protocol 7. Paragraph 129 is the point that essentially, I think my Lord Mance made yesterday. Strasbourg is not concerned, in this judgment at least, with what the criteria are, or what the definition of miscarriage of justice is, provided it doesn't infringe the presumption of innocence. They were not concerning themselves with the true ambit of miscarriage of justice and the debate in Mullin, or indeed Category 2 cases in Adams. And in that context, it will be remembered that Allen itself was not applying Category 2 in Adams. Allen predated Adams, and Allen was a case where the domestic courts had looked at whether there was a case to answer and concluded there was, because of a strong case to answer still existing on the state of the evidence. Paragraph 130 is the reference to looking at the Court of Appeal Criminal Division's judgment. And of course, that's right. That is still what happens under Section 1331ZA. It's a Secretary of State's decision, but it's taken by close reference to the Court of Appeal Criminal Division decision. 131 looks at voicing of suspicion, but concludes at the end of 131, the mere fact of powerful evidence, etc., goes well, they concluded fell well short of demonstrating beyond reasonable doubt there had been a miscarriage of justice in the case. The court was correctly focusing, the domestic courts, on the question of miscarriage of justice under Section 133. Nothing objectionable about that. And then 132 is on the same point. The appellants then attach, of course, considerable weight to paragraph 133. And in my submission, the weight they seek to place on it is not sustainable. First of all, what 133 is identifying is that as a matter of fact, because of the nature of debate that there has been around the whole concept of miscarriage of justice, there was reference in the decisions to the whole concept of innocence and whether or not that was a necessary category or criterion generally, or indeed more specifically in the context of new or newly discovered facts. And there's a reference to Lord Steyn at paragraph 133. Lord Steyn had expressed the view that a miscarriage of justice would only arise where innocence had been established beyond reasonable doubt. It's not there qualified by reference to the new or newly discovered fact point that is actually a feature of the statutory scheme. But the court simply recognising there was some discussion of that and referring to the explanatory report which Lord Steyne had used to adopt his particular test. And the court carries on that referred to clearly innocent, which of course the explanatory report does. It refers to only giving compensation in cases where people are clearly innocent. Again, not circumscribed by new or newly discovered facts. And then the court makes the point, it's wholly understandable in the context of all these debates going on, that the domestic courts have referred to concepts of innocence and debate. They then certainly say the explanatory report has to be seen in light of their subsequent jurisprudence. But then these words, but what is important above all is that the judgments of the High Court and the Court of Appeal do not require the applicant to satisfy Lord Steyne's test of demonstrating her innocence. Now, on a simple reading of what was before the Strasbourg Court, the words there, in my submission, are really directed at the fact that the domestic courts in that case were not actually looking at Lord Steyne's test at all. And therefore it simply doesn't arise for consideration by the Strasbourg Court as to whether or not that issue needs to be resolved. Because in Hallam, all the courts were doing was looking at the question of whether or not there was a case to answer. And so the High Court and Court of Appeal didn't require the applicant to satisfy Lord Steyne's test of demonstrating innocence. And that's right, as a matter of fact. And therefore it doesn't arise on the facts of this case for the Strasbourg Court to consider it. It simply wasn't the test that was used. Indeed, they go on to say, the High Court in particular emphasised that they were far removed and looked at the ratio of Mullen not assisting in the resolution of that case, and that's right. But even if it can be interpreted as a statement that above all means we are now disapproving of Lord Steyne's test, the question is, what do they mean by Lord Steyne's test? Did they mean clearly innocent, or did they mean a new or newly discovered fact which demonstrates someone didn't commit the offence? They don't say. But even if they were suggesting that it's new or newly discovered fact, which requires some heroic assumptions in the reading of one line, they don't explain why that's an objectionable test. And for all the reasons I've submitted, the Court of Appeal below accepted, Divisional Court have expressed, and Lord Phillips himself in Adams expressed, if you are focusing on a new or newly discovered fact and its effect, then you are not into the forbidden territory, and you are not violating the presumption of innocence, and you're not casting any doubt, which is the critical point, on the acquittal by the Court of Appeal Criminal Division, and the fact that the acquittal means the person is in all other respects treated as innocent. And so paragraph 134 explains in the context, this is the ratio of the decision effectively, that they directed themselves under section 133. They weren't, on the basis of the evidence, expressing a view on whether they should be or would likely be acquitted or convicted. Equally, they did not comment on whether the evidence was indicative of the applicant's guilt or innocence. If one reads that with Lutz and Knocklenboff and the acceptable Minelli principle, it is, of course, permissible to comment on the state of the evidence and whether it identifies strong suspicion, for example. Those sentences can't be read in any other context, and we know subsequently Category 2 has been accepted on that very same basis. And what the court is there identifying is that there is no general assessment of guilt or innocence of the type that occurs and is objectionable in Capo, Puig, Panella, and those sorts of cases. To the contrary, they continue, They merely acknowledged the conclusions of the CACD, which itself was addressing the historical question whether, had the new evidence been available prior to or during trial, there would nonetheless have been a case for the applicant to answer. That point about historical distinction, you recall, was a point made by Judge Grieve in Hallam in her concurring opinion in distinguishing Article 3 of Protocol 7. And it's expressed here in the context of Section 133 because it's doing something very different. And in my submission, the Strasbourg court here is drawing attention to the very nature of Section 133 and not taking you into that wider assessment of general guilt or innocence of which they have concerns, which they've expressed in these other contexts. And of course, the question of whether 1ZA, or indeed Lord Staines's innocence test as it's described here, even if it meant new or newly discovered fact showing innocence, wasn't before the court. It wasn't argued before the court. See the government's submissions. It didn't need to be argued because, of course, that wasn't the test that had been applied. So here the Strasbourg court is purporting to opine on that issue. Not only have they not explained why it would be objectionable, but they have done so without the benefit of the sorts of submissions that have been made in this case. And for all those reasons, we do submit that there is nothing in the Allen case which supports a conclusion that 1ZA is inherently objectionable or a violation of the Article 6(2) presumption, even if it's applicable in this context. And can I therefore just finally turn to 1ZA and the decisions in this case? If one applies the Strasbourg principles that are expressed in the case law that I've just identified, you can see the following features. First of all, the Secretary of State is not conducting any freestanding, autonomous, which is the word used in the language, assessment of someone's guilt or innocence in the way that was of concern in Seconina, Capo, or Pui Panella. Secondly, there is no presumption of guilt of the type that was of concern in those cases. Thirdly, the Secretary of State is confined in his assessment to the effect of one piece of evidence, the new or newly discovered fact, because the Secretary of State is confined to considering miscarriage of justice as defined in the Act. Both as a matter of substance and, of course, language, if one is entitled to make assessments of evidence of the type of Category 2, a Category 2 type case, as in Section 133 before it was amended, which allows the Secretary of State to look at the effect of the new or newly discovered fact on the basis as to its effect on the overall evidence, and that is compatible. So, in my submission, is a more confined assessment of the new or newly discovered fact and whether it demonstrates the person didn't commit the offence. And for those reasons, the Court of Appeal in paragraph 47 and 48 you were taken to this morning were entirely correct in analysing the restricted nature of the Secretary of State's task, and more importantly, so far as Strasbourg is concerned, that carrying out of that task doesn't affect, undermine, or otherwise act contrary to the presumption of innocence that flows from the acquittal itself from the Court of Appeal Criminal Division. And that is borne out by the decisions in this case that I took you to, the actual decision letters which follow and track the Court of Appeal Criminal Division's own conclusions, and no one is suggesting those conclusions infringe the presumption of innocence. And indeed, from the debate or discussion that we've had earlier today, it is, in my submission, very difficult to imagine any case where the Court of Appeal Criminal Division would not articulate the effect of the new or newly discovered fact in terms of what significance it has, which in a way which wouldn't enable the Secretary of State to carry out the task under 1ZA, i.e. to see what does the new or newly discovered fact do in this particular case, stripping away non-new or newly discovered facts which may have also affected the Court of Appeal Criminal Division's decision. And that brings me back to paragraph 58 of Lord Phillips's approach in Adams, which in my submission remains the right analysis, that if you're focusing on miscarriage of justice in this way, whether or not you apply category 1 or category 2, the whole nature of the exercise doesn't take you into questions of general innocence or guilt of a person that are of concern to the Strasbourg Court. And that is perhaps the best way of standing back in these cases, as Strasbourg often does, to see how it is that the decisions in this case do in fact undermine, if it's said they do, the acquittal that these applicants received. Not only is that point made in the decision letters themselves, that the decision on compensation, which focuses purely on the statutory criteria, does not in any shape or form cast any doubt on the presumption of innocence, but merely looks at the effect of the new or newly discovered fact. That is also the case in substance in my submission for the reasons I've explained. My lady, in the written case, the appellants have also sought to raise an argument, I think the second appellant, in writing about the construction of Article 14.6 in terms of miscarriage of justice. We've dealt with that in our printed case. It hasn't been pursued orally, but we've given you the reference to particularly Lord Clark in the Adams case. They're in the printed case, that this was ultimately a matter for Parliament to decide how to define miscarriage of justice. And that, of course, is precisely what Parliament has done in enacting Section 133(1)ZA in the form it has. For those reasons, my lady, we invite you to dismiss these appeals on either of those two bases. Can I just make two brief observations about the justice submissions you heard earlier and the written case? The first relates to resort to parliamentary debates of the type that were looked at. Of course, your courts looked at them and will make of them what they will, but as a matter of principle, I do submit it's difficult to see what basis or what admissibility basis they
We'll
have.
think about that up for ourselves. We're
frequently
faced with these sorts of arguments and materials. So,
and the second point, my lady, just relates to the question of the evidence that's been put in about other jurisdictions. That came to us 10 days ago. We have not had any opportunity, I say sufficient opportunity, to verify or confirm the position in other jurisdictions, or indeed the sources upon which that's made. But I leave it. I just wanted that to be clear, but I can't offer you any further assistance on.
well, if you want to look at it and put in anything to tell us that something wrong about it, well,
I think the general observation I make at this stage is that the question of what happens in other jurisdictions has no relevance to the strict question of whether 1ZA is compatible with Article 6.2 or not, or indeed applicability. My lady, unless I can assist you further, those are our submissions.
thank you very much, Mr. Strawn. Mr. Gullick? Now, how are you going to do the reply?
We're going to do 15 minutes each, my lady. And apart from the point that I want to turn to relating to Mr. Hallam's case, I'm going to deal with issue 1 and my learned friend with issue 2, as we did with our opening submissions. So, my lady, back to issue 1. My learned friend Mr. Strawn says that Article 6.2 has no obvious purpose in the context of a compensation scheme that reflects Article 14.6 of the International Covenant on Civil and Political Rights, as opposed to a voluntary scheme. Respectfully, we disagree, my lady. Whilst the terms of a scheme that does no more than reflect 14.6, as was the case with the unamended Section 133, whilst the terms of it will not in themselves violate the presumption of innocence, obviously, because as my learned friend has pointed out, the two need to sit together, 14.6 needs to sit 14.2 in the ICCPR. But that is not to say that there is not scope for the presumption of innocence to be called into question, and therefore a role and a rationale for the presumption in this area. And that may arise in one or both of two ways. Firstly, where the terms of the eligibility criteria, as we have seen with 1ZA, are amended so that they no longer simply reflect the analogue provision in Article 14.6, but indeed seek to restrict the circumstances in which compensation can be claimed. And secondly, it may well be, as I highlighted in my opening remarks yesterday, in the language used by the decision maker. So one may have, as indeed is illustrated by a number of the voluntary schemes, decisions to adopt my learned friend's terminology, one has a scheme that is on its face, on its terms, unobjectionable as regards the presumption of innocence. The Netherlands scheme that my learned friend Mr. Strawn took you to would be an example where the test for obtaining compensation was simply whether it was equitable to do so. That test did not of itself offend the presumption of innocence, but as the European Court of Human Rights recognised, there was potential for the decision maker in making any particular decision under that scheme to violate the presumption. And indeed, you have illustrations in both the Bars case, tab 45, and the Del Lart case, from memory, I think tab 47, where exactly that happened. And therefore, the rationale, which I began with yesterday, the need to make the presumption of innocence practical and effective, to respect an acquittal in this area, applies just as much to a compensation scheme that reflects the provisions of Article 14.6 and Article 3, Protocol 7, as it does to what my learned friend terms voluntary schemes. So the rationale is the same. Secondly, the point that my learned friend makes, as I understand it, is to say, and this is obviously a link point, well, if you look at the terms of Section 133 or another scheme that reflects Article 14.6 and or Article 3, Protocol 7, you can simply see there's no violation and therefore the presumption need not apply. I've effectively, I hope, answered that point as well by the observation I have already just made. Strasbourg does not, as you saw in all those cases I took you to yesterday where Strasbourg applied the link test. One thing notably Strasbourg does not do in deciding if the presumption of innocence applies, it does not say, oh, well, let's look at the terms of this test and see if it's likely to violate the presumption. That is an inquiry that happens at the second stage once it is decided that the presumption is engaged. That is a point that is considered at the compatibility stage. At the question of engagement stage, the court looks to precisely the factors that I took you to in the authorities yesterday morning and sought to distill from them. And indeed, my learned friend has not taken issue with any of that analysis. Obviously, he says Section 133 is a lex specialis, but I don't understand him to dispute if it is not a lex specialis I don't understand him to dispute that the link principle is the test that applies, and that the factors which one should take into account are those which I highlighted to you yesterday morning, and which plainly point to the engagement of the presumption in relation to section 133. My learned friend points to the fact that the section 133 eligibility criteria is narrow. That is undoubtedly true, but the eligibility criteria was narrow in various different ways in the various voluntary schemes. That in itself respectfully tells us nothing about whether Article 6.2 is engaged or not. And so, aside from the lex specialis point, which I will come on to in a moment, aside from that, looking at the test that Strasbourg applies, taking into account the factors that Strasbourg takes into account, they all point in this case to the presumption being engaged in relation to section 133. As regards the lex specialis issue, the essence of my learned friend's submission is that paragraph 105 in the Grand Chamber's decision in Allen is insufficiently reasoned or provides insufficient material for you to follow that rather than the view expressed by the majority of this court in Adams. So could we perhaps just turn that back up again? So it's paragraph 105 in Allen, which is page 966 in the electronic references. I just want to go through the points that are made by my learned friend in relation to paragraph 105. Firstly, he said the first sentence was just assertion and sort of dismissed it. Well, my lady, that's not right, because there is a very important point made in the opening words before the comma in the first sentence, having regard to the nature of the Article 6.2 guarantee outlined above. And that is plainly a reference back to the points made in paragraph 94 and 99 through to 104, looking at the rationale and the circumstances in which Strasbourg has found Article 6.2 to be engaged in relation to post-acquittal compensation schemes. So that's an important point in itself, which my learned friend simply dismisses. Then we come to the passage in paragraph 105, the meaning of which my learned friend has questioned, and there was some discussion of this morning. In our respectful submission, what the court is saying here is that Article 3, Protocol 7 does not have its own guarantees, does not include its own guarantees separate to Article 6.2. It doesn't create a special regime which displaces 6.2. And that, perhaps the sentence is, I say respectfully, not quite as clearly expressed as the majority of this judgment, but that, in our respectful submission, if one reads it carefully, is plainly what is being said, and also that then fits with the text that appears immediately before and after. And that is a perfectly sound and sensible point to make, that there is nothing in Article 3, Protocol 7, that suggests or points to the presumption of innocence not applying. Then the third point which is made in that paragraph, which respectfully my learned friend rather glided over, is the point about Article 7 of Protocol 7, saying, we looked at it yesterday, but saying in effect these rights are additional to those under the Convention. That in itself is a very powerful indicator that unless there should be something clearly pointing the other way to displace that powerful indicator, a clear indication that the rights contained in the Convention, including Article 6.2, apply.
Are both sentences not leading up to the conclusion in the last sentence about lex specialis?
Indeed, my lord, exactly. We would.
The point being addressed in the sentence beginning the two articles is that there isn't a lex generalis in Article 6.2 which one finds specifically applied by Article 3 of Protocol 7.
Yes, indeed, my lord. And the fourth point, or maybe the third point that my learned friend made, was in relation to the May Weir case, which is footnoted. It is quite apparent from the text of that footnote that the court is saying compare and contrast. And as was pointed out in discussion this morning, when one does look at that case, and I summarised it in answer to a question from my Lady Howe yesterday morning, it is quite clear that that was a case where, in contradistinction, there was a specific reason for construing Article 1 of the 7th Protocol as providing its own system of rights, separate to, in that instance, Article 6.1 of the Convention. So, in fact, they all interrelate together, but there are 4 points made in that paragraph, including the footnote, which are all good sound points, which all explain why neither Section 133 or Article 3 of Protocol 7 is to be regarded as a lex specialis. And they, in our respectful submission, entirely meet the points that were made by this court in Adams and by Lord Steyn in Mullen. And lest there be any doubt about the Grand Chamber's view, of course, I simply remind my lady, I know you've been taken to this before, but of course when one comes on to paragraph 133, which is towards the top of page 973, you will recall there is the reference to the explanatory report, and how the passage in the explanatory report suggesting that an innocence test applied in Article 3 Protocol number 7 had been overtaken by the intervening case law on Article 6.2. So another clear indication that the Grand Chamber took that Article 6.2 case law not as something separate only applying to voluntary compensation schemes, but as applicable to Article 3 Protocol 7. And plainly there is no reason whatsoever for this court to take a different interpretation of Section 133 in terms of lex specialis to that which the Grand Chamber plainly would take in relation to Article 3 Protocol 7. WJH was decided in 1992. The applicant was unrepresented in that case, so it is unlikely there was any significant legal argument before the United Nations Committee. And my learned friends accept it hasn't, were the issue to arise again in front of that body, plainly the Strasbourg jurisprudence would be cited and considered. Judge Grieve in Hallam, the observations that she makes that my learned friend takes you to 2 points to make about that. Firstly, she is talking about violation, when Article 6.2 would be violated as opposed to when it applies. And secondly, she is, of course, talking about an unamended new fact miscarriage of justice test. She is not gazing into her crystal ball and making a prediction about 1ZA. And so that doesn't carry weight. So clear and constant line, yes, because the link test has been applied since at least 1993, consistently by Strasbourg, and when Strasbourg Grand Chamber, 17 judges, was asked to consider the lex specialis point, a clear and detailed reasoning, highly authoritative, and has been applied in the cases you have been taken to since then. My lady, 2 very short points. Civil proceedings, we say the test is clear. There may be occasions where its application seemed to our eyes to be less than entirely straightforward, the Orr case being an example. But that is not a reason not to adopt our submissions in relation to Section 133. Whether or not you decide Section 133 is a lex specialis will shed no light, quite frankly, one way or the other on such difficulties as may be thrown up in relation to the line of authority considering civil proceedings. Because, as I say, in relation to post-acquittal compensation, the link test is completely clear, completely consistent. If it's not a lex specialis, you apply that. And so such difficulties that arise from civil proceedings are for another day. Then I just need to deal very quickly with a point in relation to Mr. Hallam's own case, which I haven't yet had a chance to address. My lady, were it to become significant we do say, and you've seen this in our written case, I'll just give you the references. It's paragraph 6 to 9, electronic pages 97 to 99, and paragraph 106, electronic page 126. We do say that this is a category 2 case. The reason for this, and I need to make this clear because of the point my learned friend made this morning suggesting it was what he called a cumulative issue. If one looks at, and I'll just give you the reference because of time rather than taking you to it, if you look in particular at paragraphs 75 to 79 of the Court of Appeal Criminal Division, judgment quashing his conviction, that's electronic pages 260 to 261, you will see it is very, very clear. Weak identification evidence, Turnbull, proper support required, in light of photos found on his phone. The one possible candidate for proper support, namely the proposition that he had lied about his alibi, had completely fallen away. So absent that, there was no supporting evidence as required by Turnbull. There is no case to get off the ground. There is no case to go to a jury. It is a case where the evidence, the new evidence, completely undermined the basis for prosecution. It is plainly a category 2 case. And that is relevant, my lady, for 2 potential reasons. One, because it underscores the importance of obtaining a declaration of incompatibility in this case, because if Parliament revisits the miscarriage of justice test, even there is a real prospect of Mr. Hallam obtaining compensation. And secondly, if and insofar, Malone from Ms. Rose is going to address you on the fact that even if these were discontinuance cases, then Capot and that line of authority shows that the 1ZA test is objectionable. But I simply have to make the point as well on behalf of Mr. Hallam that in any event, on no view, is his a discontinuance case. It is a case where on the Court of Appeal Criminal Division's finding there can be no basis for a prosecution. It is on any view an acquittal on the merits. And paragraph 127 of the Grand Chamber in Allen simply says that Mrs. Allen's case had some of the features of a discontinuance case. It doesn't say all cases in which the Court of Appeal Criminal Division in the British system in which a conviction is quashed as unsafe will be discontinuance cases. So I need to make the points on my client's behalf. And perhaps just the very last thing, I'll just go back to the Secretary of State's letter because my learned friend referred to it. It's at pages 272, 273. Second paragraph, I commend the whole letter to you, which makes it quite clear the basis upon which the Secretary of State is proceeding in terms of why the conviction was quashed. But in any event, I just draw your attention to the second paragraph on the second page of the letter, so that's page 273. In any event, the Secretary of State does not consider the new evidence before the court shows beyond reasonable doubt Mr. Hallam did not commit the offence. That is why the presumption of innocence.
What about the rest of those paragraphs? I mean, how's your submission that new evidence undermined the prosecution and there couldn't be another trial really stand with that? The court expressly refused to make that finding.
My Lord, the court refused when invited by Mr. Blackstone to make the positive finding that he was innocent. If you look at the paragraphs in question, perhaps I could take you to you very quickly.
It's the difference, isn't it, between saying that there wasn't a case to answer and saying that it's perfectly clear he didn't do it.
Yes, indeed, but it's perfectly clear, respectfully, my Lord, from, for example, paragraph 77 and 78 of the Court of Appeal Criminal Division's judgment. Proper independent supporting evidence was essential on the facts here. The proper support for the Crown's case has fallen away. There simply was no supporting evidence. So on a Turnbull approach, which plainly applied, there could not be a conviction. And so we've accepted all along this isn't a Category 1 case. If it was a Category 1 case, we wouldn't be here. We'd be involved in assessing the compensation. But it is plainly a Category 2 case, my Lord. I'm very conscious that I need to give way to Miss Rose. So unless I can assist you further.
Yes. Thank you.
Sorry.
My lady, addressing issue 2, the respondent says that section 133 1ZA requires the Secretary of State to consider only the new fact And it's only if the new fact establishes beyond reasonable doubt that the individual didn't commit the offence that compensation will be payable. But we submit that cannot possibly be the right interpretation of Section 133, because a new fact considered on its own is never going to be sufficient to establish guilt or innocence. In every case, the task of the Secretary of State will be to consider looking at the evidence that was given at the original trial in the light of the new fact, whether or not innocence has been established, because the new fact in isolation won't be sufficient to answer that question. And to give the simple answer of DNA, if you find a particular unknown person's DNA on a garment, the question whether that's sufficient to establish innocence is going to depend on what the evidence was about the nature of the attack and whether it's likely that the attacker's DNA would have been on that garment. So you can't just look at the piece of evidence in isolation. And that's the premise for his argument, and we submit it's false. He then says, and he accepts rightly, that whatever the Court of Appeal Criminal Division has said, the assessment under Section 133, the substantive assessment, is a matter for the Secretary of State. And that is the vice here. Because there will be many, many cases where the Court of Appeal Criminal Division doesn't say, one way or the other, whether the unsafe conviction is unsafe because the individual has proved that they were innocent, because that's not the statutory question before the Court of Appeal. The Court of Appeal is only required to say whether the conviction is unsafe. And it's then for the Secretary of State to address the question whether the newly discovered fact establishes innocence. And even, of course, in a situation where the Court of Appeal has addressed that question, it doesn't bind the Secretary of State. So you could have a situation where the Court of Appeal, as happened in Mr. Hallam's case, said, well, we're not prepared to find that innocence is established, but where the Secretary of State says, well, looking at it and looking at the submissions of the type just made to this court by Ms. Williams, I think actually innocence is established. So it's never simply a question of the Secretary of State rubber stamping the Court of Appeal. The Secretary of State's making the substantive judgment of innocence or guilt based on a reversal of the burden of proof. And that's why the system is flawed. Turning to the question of clear and constant jurisprudence, there are 9 cases in the bundle before this court following Allen in which the European Court of Human Rights has applied Allen and applied it specifically. 3 of those are cases that concern Section 133. One of those 3 cases was notified to the United Kingdom government, and the United Kingdom government made submissions and put in issue the applicability of Article 6.2. That's the case of KF. And my junior counsel was instructed in that case and has seen the United Kingdom's observations, and they put in issue the applicability of 6.2. Of the other 6 cases which concern other schemes, 4 of them were notified to the member state and submissions were made by the member state, as you can see from the face of the judgment itself. And we submit that is indeed clear and constant jurisprudence, and the dicta in Chester apply. It's simply not good enough for the government, when it loses a case before the Grand Chamber in Strasbourg, to seek to re-argue the same point, the same argument that has failed before the Grand Chamber, and to persuade this court not to follow the Grand Chamber on an issue of the substantive interpretation of a convention right. Turning then to the question of infringement in Allen itself, central to my learned friend's submission is the argument that at paragraphs 133 and 134, the court was not addressing the test in section 133, in other words, whether the newly discovered fact shows guilt or innocence. That's not correct. Of course, it wasn't addressing the amended 133 because 133 hadn't been amended. What it was addressing was 2 tests. First of all, the test enumerated in the explanatory report, which it expressly disapproved. And secondly, the test that had been devised by Lord Steyne in Mullen, which it expressly disapproved. It set out both of those tests in its judgment, and both of those tests referred to the new or newly discovered fact establishing innocence. Just to go back to it very quickly, we see the explanatory report is at page 959. And you can see that here in Allen itself, at paragraph 72, the court sets out the two key paragraphs of the explanatory report. And the report starts by saying at paragraph 23, in either case on the ground that a new or newly discovered fact shows conclusively there's been a miscarriage of justice. And it's in that context that at paragraph 25, it then goes on to say that it's only in clear cases of miscarriage of justice in the sense there be acknowledgement the person concerned was clearly innocent. And then at the end, where an appellate court's quashed a conviction because it has discovered some fact which introduced a reasonable doubt as to guilt overlooked by the trial judge. So the test in the explanatory report is clearly devoted to the question whether the newly discovered fact establishes innocence, and that is ruled by the court to be superseded by its case law. And similarly, Lord Staines's test was based on the same premise, and that's set out by the court as well. It's at page 956, paragraph 60 of the judgment, where they set out Lord Staines's test, and they quote paragraph 46, the requirement that the new or newly discovered fact must show conclusively or beyond reasonable doubt that there has been a miscarriage of justice is important, and then goes on to establish his clear innocence test. So it simply cannot be suggested that the European Court of Human Rights was unaware at paragraph 133 that the tests it was disapproving were based on the question whether the newly discovered fact established innocence. That is made absolutely explicit at paragraph 134. And I made submissions to the court earlier today about the points that you derive from 134. And if I invite the court to return to those submissions, you'll see that all of those points are premised on the new evidence. That was
and I mean, you haven't got time to go to 130, but I think if you had time, you might have drawn that to our attention, because they're talking about new facts.
Yes.
In context.
Yes, my lord, that's absolutely right. That's absolutely right. And that, not surprisingly, is the entire focus of the court in Allen, because they're considering section 133. And in its unamended form, section 133 was always focused on what a newly discovered fact showed. It was simply that a newly discovered fact showed a miscarriage of justice. And what the court's saying here is, to require the newly discovered fact to show innocence is a breach of Article 6.2. And that is what Parliament subsequently enacted, and that's a clear breach of 6.2. Finally, on the question of capo and quid panella, my learned friend suggested that the reference there to a requirement without qualification is referring to a general compensation scheme that doesn't have any requirements or limitations in it. That's a misreading of those judgments. What is said, and it's capo, it's paragraph 25, the page reference is MS 2088. What the court is objecting to is the unqualified requirement to show innocence. In other words, by contrast with the type of requirement that Lord Phillips imposed under Category 2, which is to say that there isn't a case to go to the jury. And it's that the court is saying is unobjectionable, not simply a scheme that doesn't have any requirements or qualifications. So my learned friend is simply misreading capo and quid panella. In relation to Mr. Nealon individually, the decision letter in his case is at MS 235. I don't have time to go to it. Our submission is that this is also a Category 2 case. In circumstances in which the identification evidence was always pretty unsatisfactory, and where there is now a visible saliva stain on a brand new blouse, DNA belonging to an unknown male and DNA with strong similarities on her bra, which her evidence was had been touched by the attacker, we submit that that case couldn't have gone to a jury. But of course, this is not a case that turns on the facts of these individual cases. Our submission is it's the scheme, it's the statutory rule which violates 6.2, and for those reasons we seek a declaration of incompatibility. Thank you very much.
Thank you. And thank you to everybody. It says precisely 3:30 on the clock on my machine, which is the one that I always go by. So you are to be congratulated for having got through it in the time allotted. And we will now go away and think very carefully about all the submissions which we have received. Thank you all very much indeed. Court is now adjourned.